Dear participants, we are privileged today to have with us Khadim Hussain Malik Sahab from Punjab. Sir has remained as a district and sessions judge and has also remained as a director Federal Judicial Academy for 3 years. Sir has also been a director in the Punjab Judicial Academy for about 2 years, and Sir has a very rich experience of almost 35 years as a judicial officer. And Sir has been also a faculty member of the Punjab Law College and has a very rich experience of educating the judicial officers as well. Today, Sir would be sharing with us and with you his rich experience and knowledge on the formal topics of discharge of accused and also on the cancellation of cases. Since you people have been appointed and now you are posted as a judicial magistrates, and since you people were also very keen about knowing about the magisterial trial of an accused, therefore, you would be pleased to have a very, very rich and experience-based knowledge on the same, and you are at liberty to put any query to the Sir, and you will inshallah get a very satisfactory reply to the same. And try to get benefited from the experience-based lecture of Sir. Over to you, Sir.
Thank you. We will be having discussion about cancellation of a case. These two topics are in a way interconnected. So many topics are interconnected. You might have received a paper having the synopsis of the topic of discharge. Have you got it? Yes. Please just go through it just for 4 or 5 minutes. Then I will be coming to you and discussing each and every item and giving you a short answer, and then ultimately I will be switching over to the PowerPoint. So just go through that paper which you have just received.
Sir, no such document has been given, sir.
You haven't received it?
No, sir.
All right, all right. इसमें है I will just read it out. अगर आ गए हैं तो ये please distribute it hurriedly. The first one is what is the concept and scope of discharge. It means कि what actually is meant by discharge. क्या आप में से anybody can tell me? You have been advocate. The discharge, what does it convey? Temporary release. Yes. It is just a release from the custody. We may say that if the police finds him innocent in the investigation or otherwise the case is not made out, it does not amount to acquittal, it does not amount to that he is not to ultimately face the prosecution, and so forth. How, by whom, and at what stage of the proceeding an accused person can be discharged. How? Section 63, which says that if any person is arrested, he may not be discharged except on his bond or on bail. तीसरा क्या है? Special order of the magistrate. अब question is कि क्या police, whether police can also discharge an accused? Under what provision? 169, good. Because 169 also says if there is no sufficient evidence, he may, after taking the bond, release him. But that does not mean he is totally free. Because when the ultimately challan or charge sheet will be received, you may summon him. So police is also competent. The bail granting court is also, when it takes the bail, it amounts to virtually the discharge of the accused. Because discharge means just release from the custody. Whether discharge is possible at this stage when police requests for remand under section 167? Yes. Magistrate, an accused is produced before a magistrate. Police wants that he should be remanded to judicial custody, and you see that there is no sufficient material. You can straight away, you can refuse to grant judicial remand and you may discharge him. But what should be the status of that magistrate? Is any magistrate competent to discharge him? इलाका मैजिस्ट्रेट. इलाका मैजिस्ट्रेट की डेफिनेशन क्या है? एक मैजिस्ट्रेट who is competent to take cognizance of the offence and to send the accused and to try the accused or to send him for trial. हर एरिया मैजिस्ट्रेट जो है, he is to take cognizance of every challan, of every police report, whether the accused involved in that case is triable by him or by the sessions court. The cognizance primarily is taken only and only by the magistrate, area magistrate we call it, ilaka magistrate we call it in the common parlance. But CRP speaks of a such a magistrate who is empowered to take cognizance of the offence and to try the accused or to send him for trial. Relevant provisions of High Court rules and orders, I will just discuss with you. This way, it has been pointed out that whenever a magistrate receives a complaint, a police report, charge sheet or challan, if he is a magistrate who is competent to take cognizance, first of all, what he is to see whether it's a case of discharge. This is what the High Court rules and orders says. The very first point which you have to determine is whether it's a case of discharge. If it is, you proceed with it. Its second para provides, if you are not that magistrate, if you are not ilaka magistrate, if you are not competent to take cognizance or to try the accused, then what to do? If you are to grant him a remand, well and good. You may send him to judicial remand, well and good. But if you consider this further detention is unnecessary, and you are not the area magistrate, then what you are to do? What you are supposed to do? You are supposed to do to send the accused to the magistrate who is competent. Here the problem does arise. You are a duty magistrate. You are not area magistrate. Police comes and asks that this man is to be discharged. Should you discharge him? No. ये पंजाब में बड़ी एक प्रॉब्लम. Whenever I had been delivering a lecture, the people would come out. What to do then? The answer is not given in CrPC. But rather, this subsection 2 of section 167 also provides that if you consider further detention unnecessary and you are not the ilaka magistrate, then you should send him to the ilaka magistrate. But if the ilaka magistrate is not available, if he is also on leave, if he is not available, then The remedy which, according to me, is your session judge may authorize you for that particular period of duty to also work as a local magistrate, so that this problem may not arise. After alakas are distributed by him, the thanas are allocated by him. So why not he should entrust you with this power as well, so that this situation may not arise. और यही है discharge by duty magistrate, you have answered it. If you are not competent, there would be two case laws on this point when the order was set aside by the Lahore High Court. Whether a magistrate is competent to pass an order of discharge in a case exclusively triable by session court? No, sir. सबका view यही है. It is correct view. The correct view is it is only whether you are to cancel the case, Ilaka magistrate, nobody else. Whether you are to discharge the accused, it is the Ilaka magistrate. In both ways, the power vests with the Ilaka magistrate. Is there some confusion? No. So I will discuss with you the case law. Whatever I'm taking, whatever I'm saying, I'm not talking of my own. It's all supported with case law. And you will be handling the maximum case law on each item. Yeah? No revision, no appeal. It's administrative order. You have the remedy. Have 199 or 561A inherent power. No regular appeal, no revision. Only remedy is this. The party may go in for filing a complaint. Complaint is as competent. You have discharged the man. The party complainant comes with a complaint on the same ground. You are competent to entertain it. You are not debarred. His remedy is open. He have all the three remedies. Either 199, 561A in some very unusual cases. And I will also discuss with you as to what parameters you have to take, how your order should be. It should be speaking order. It should be well-reasoned order. It should speak as to why. It should show that you have applied your judicial mind. Otherwise, the superior courts will not interfere if you have given cogent reason for your orders. What is the effect of discharge order? Whether it amounts to smothering the investigation? क्या investigation खत्म हो गई? अगर investigation already चल रही है, it may continue. And if after some time police finds fresh material, it may re-investigate the matter and submit challan. Cancellation of case? No. Termination of proceeding? No. Acquittal? No. Whether the discharge accused can be associated in investigation without the permission of the magistrate? क्या परमिशन दरकार है? नहीं. लेकिन अगर पुलिस ने अरेस्ट करना है, फिर आपको अप्रोच करना पड़ेगा कि आप अपना ऑर्डर रिकॉल करें ताकि वो उसको अरेस्ट कर सकें. अरेस्ट के लिए परमिशन की ज़रूरत है, इन्वेस्टिगेशन के लिए नहीं है. Difference between cancellation of case and discharge of accused. This topic we will also discuss in cancellation of case. My dear participant, in the cancellation, there is no FIR. The FIR ceased to exist. So no investigation without permission and no arrest because there is no FIR. FIR has been cancelled. So nothing doing. So difference is in cancellation, the FIR remains intact. FIR remains, comes to an end, but in discharge it remains intact. So if the FIR is intact, investigation can be continued. In the cancellation, no investigation. But in the discharge, investigation can be had. This is the difference between the two. Nature of discharge order, it is an administrative order. So administrative order can't be assailed in appeal or revision. As I just told in response to your question, the only remedy is either for a writ under 199 or 561A CrPC inherent power. But that too would be very unusual. Any case which is on the face of it. So sometimes our judges say, whether it's a cancellation offence or discharge, agreed with police, the person is discharged. This is an order. Agreed with the police, the case is cancelled. No order. Both are administrative orders. Whether it's a discharge or it's a cancellation. They same and the same. And in both the cases, it's the magistrate, area magistrate, who is competent to pass either of the two orders. Difference between discharge under section 63, whether and when discharge order can be interfered with by higher court. Higher forum, ये अभी मैंने आपको बताया. Difference between discharge order under section 63 and discharge under subsection 3 of section 173. Now discharge in 63 means he is released from custody for the time being. And then in exercise of your power under subsection 3 of section 173, you discharge that man from the bond which he executed to the magistrate, to the police officer. And if you discharge him from that bond, then he is free. Meaning thereby, that no prosecution is further to be taken against him. This is the difference between the two. Whether discharge is possible after taking of cognizance of the case by trial court? नहीं. जब आप कॉग्निजेंस ले लेते हैं, अच्छा कॉग्निजेंस से क्या अपराध है? नोटिस किसका?
To take notice of the offence for the purpose of trial, sir.
इशू करना नोटिस कोई? Yes. देखें ना, you have received this police report. You have gone through it. This is judicial taking your application of mine. You don't pass any order. You keep it pending for the next day. Have you taken cognizance? You have applied your mind? No. Because some action must be taken to show that you have applied your mind. That action is not required for application of mind. That is not the concept of taking cognizance. Taking cognizance primarily means the connotation is to apply your judicial mind. And then the order should reflect as to in what way you are to proceed with that matter. Are you going to issue him notice? If you issue him the notice, that means you have taken the cognizance. Otherwise, cognizance does not speak of taking some positive action. Positive action is the result of your taking cognizance. Positive result is taking of cognizance. Taking or passing an order is not taking of cognizance. It is the consequence of taking of your cognizance. Is it clear? So आपने उसका जवाब सही दिया. Summoning of accused placed in column 2 of charge sheet or challan. Police has found him innocent, placed him in column number 2. You discharged him in exercise your powers under section 63 and the accused is placed in column number 2 of the challan. Whether you can still summon him? Yes. And for that matter, क्या आपको कोई मज़ीद एविडेंस लिखने की रिक्वायरमेंट है? नहीं, क्योंकि the already material जो अब है, if you go through that and you come to an opinion कि yes, there is some ground to proceed with him, you can summon him. The next important heading is summoning of accused placed in column number 2 by magistrate in case exclusively triable by sessions court. आपके पास सेशन कोर्ट का केस आया, मुल्ज़म खाना नंबर 2 में है, आप अपने ट्राइबल केस को में अक्यूज नंबर 2 को, खाना नंबर 2 वाले को, तो एज आई जस्ट टोल्ड यू कैन समन इट. That is a proposition which is well settled. Insofar as the problem does arise in the case of which is triable by exclusively by the session court, whether you can summon him or not. You can. You can. It is not Khadim who is saying, I will share you with the so many case law, so many case law, starting from 1925 till 2010. In between, what is the logic? When you take cognizance of an offence, you take cognizance of the offence, not of the offenders. You take cognizance of the case, of the offence, not of the offenders. Gone are the days when there were commitment proceedings. Wahan magistrate would hold an inquiry and then he would send the case to the session court. Say, sir, 2 accused, I have discharged them because no case is found against them. The 3 are sent up to you. The session judge would only summon those 3. But now with the change of the law, by the Law Reforms Ordinance 1972, the magistrate take cognizance of the case, of the offence, not of the offender, and he may summon any person, even if he is not involved in that case, even if he is not mentioned in column number 3 or column number 2. But somehow or the other, you come to know of it, that some person is also involved. But there should be some material. You may summon that person as well. When I was session judge, I saw a challan. I went through the FIR, the case diary. There were 3 or 4 accused persons. 3 of them were mentioned in column number 3. The remaining were not mentioned in column number 2, and there was no mention as to what happened to those 2 persons. I asked the district attorney as to, you have passed this challan, what about those 2 persons? उसकी जो बदनीति थी वो पकड़ी गई. He in a way had aligned with those accused persons and perhaps gave them an assurance that I will not mention your names either in column number 3 or column number 2, and you will just escape the eye of the session judge. But I summoned them. This is when those persons are specifically mentioned in the FIR or in the case diary. But I am talking of even a person who is not mentioned there. And you come to know of it, somehow or the other on the basis of some material, that is also involved. And if that person is present in the court, you may arrest him straight away. I will support my discontention with the case law. There are about 8 or 10 judicial precedents on this point. 2 or 3 of the Supreme Court. Whether the discharge accused on appearance is required to file bail application before the competent court or is required to execute a bond with or without sureties for his future appearance. Bond, surety bond, क्या करेंगे? बेल करेंगे, छोटी बॉन्ड, जी? डिस्चार्ज किया वो तो है, वो तो एक छोटी बॉन्ड तो था, अब है आपने उसको समन कर लिया, समन कर लिया, उसको पॉइंट तो ये था कि you will appear before the magistrate as and when required. That bond was only to that extent. Now you have summoned him. You have summoned him. क्या करेंगे? बेल करवाएगा या बॉन्ड करेगा? क्या लॉ इस पर कौन सा है? कोई लॉ नहीं है. बेल कराएगा. जो बेल वाले हैं वो हाथ करना करें. बस 3, 4 और बाकी सब जो हैं बॉन्ड वाले या किसी तरफ भी नहीं वाले हैं. तो यू आर नॉट बॉन्ड. I let you know, in 1986, there was a judgment by Mr. Justice Muhammad Rafiq Tarak, who remained President of Pakistan as well. That was on a case, on a complaint case. The person was summoned. It was directed that you should buy bail application because it was a session case. The session had directed that you file the bail application, otherwise I will send you to the judicial lockup. It was decided in the light of section 91 of CrPC that when you summon some person and the court is empowered to issue summons or warrants, and in response to the process issued to him, he appears in your court, you may ask him to execute bond with or without sureties for his appearance in future. And in case he does not file that bond or does not find the requisite sureties which you have asked, then you may send him to the custody, not otherwise. But if he subsequently submits it, then it's all right. This law was being followed from 1986, Mother Hussain Shah versus State, 1986 PCR LJ 2395 Act which said. It remained operative up to 2010. Rather, up to 2005, Karachi Bank, decided by Mr. Justice Khadim Hussain Malik, he said that when in a complaint case, any person is summoned, he will have to apply for bail. Then, 2010, Lukman versus Hazaro, PLD 2010, SCMR page 611, he said that even when a person discharged is summoned, he will have to apply for bail. Now this position, which was being followed since 1986, underwent a change with this judgment of the Honorable Supreme Court. Because here, again, the matter was decided by Mr. Justice Khadim Hussain Malik. Both these judgments, Noor Nabi case, which was decided when he was judge of the Sindh High Court, Karachi, and Lukman versus Hazaro, both these judgments recently have been set aside by the Honorable Supreme Court, and both these judgments have been declared to be per incurium. Thank you. What is per incurium? Any judgment Any case which is against the settled law or which is against the statutory provision, that is called technically that it is per incuria. So it is not only against the statute, which is 91, when you summon anybody, whether in a complaint or as a khana number 2 mulzam, you are supposed to ask him to execute a bond. And then the case law. 1986 judgment was subsequently affirmed by the Supreme Court in 2 subsequent judgments, which escaped the notice of Mr. Justice Rahman Hussain Malik. So this judgment is 2014, PLD 2014, पेज 14 तो मैं अभी लिखवा दूंगा आपको, सर्वर वर्सेस स्टेट 2014, PLD 2014 सुप्रीम कोर्ट पेज में अभी आपको लिखाता हूँ। तो ये तो है इसमें, ये जो हमने डिस्कशन की, इसमें फ़र्क क्या है? देखिए, जब आप चालान में प्रोसेस इशू करते हैं किसी भी बंदे को, तो सेक्शन कौन सा होता है? Under what section you issue the process?
204, sir.
2004.
204.
204.
204, sir.
204. आप उसको समन करते हैं कंप्लेंट में, तो प्रोसेस फिर भी 204 में। आप उसको खाना नंबर 2 वाले को तलब करते हैं, तो प्रोसेस फिर भी 204 में। 204 में जो लफ्ज़ इस्तेमाल हुए हैं वो है सफिशिएंट ग्राउंड। The terminology is different. When you issue a process in pursuance of or in the light of section 204, the word used are when you have sufficient ground to, you say that there is sufficient ground to proceed against the accused. But when you go through the terminology used in section 497 जो बेल का है, वहाँ क्या लफ्ज़ है? Reasonable ground. क्या दोनों में फ़र्क है कि नहीं है? क्या फ़र्क है? रीजनेबल ग्राउंड्स किसको कहते हैं? विच अपील्स टू द रीजन ऑफ ए प्रूडेंट मैन, जो हर एक को अपील करे। एवरी वन हु इज प्रूडेंट ही शुड अपील हिम कि देयर इज रीजनेबल ग्राउंड दैट यू हैव कमिटेड एन ऑफेंस पनिशेबल विद डेथ और लाइफ और दिस एंड दैट। बट व्हेन यू से सफिशिएंट ग्राउंड, इट मे बी सफिशिएंट फॉर मी, क्या नेसेसरीली आपको भी वो सफिशिएंट नजर आएंगे? नहीं। तो दिस टर्मिनोलॉजी हैज आल्सो बीन डिफरेंशिएटेड इन दिस जजमेंट ऑफ द सुप्रीम कोर्ट, जो मैंने ये आसिफ सईद खोसा साहब की जजमेंट है।
I think, sir, 1762 page number, sir.
Oh yes, thank you. 1762, right you are. किन्होंने कहा है? Yes, well, right you are. आपका, you are young and I am younger, तो मैं भूल जाता हूँ इतना कुछ याद नहीं रहता। तो anyway, this is the topic. Now we will go through the case law. कुछ ऐसे लगता है कुछ साथी जमाइयाँ ले रहे हैं, कुछ नाश्ता तो ज़बरदस्त किया है या क्या है? Yes, you can, but there should be, I just told you, police comes to you, you are the area magistrate, you are the local magistrate. High Court rules and orders require that you must first of all see whether it is a case of discharge. Police is not asking for discharge. Normally police does ask.
Sir, party पूछ सकती है की तरफ से application,
वो कोई जरूरत नहीं, कोई आएगी नहीं, क्योंकि उसको तो कोई हेयरिंग का कोई नहीं है। लेकिन आपने कहा ना सुओ मोटो, तो सुओ मोटो की बात ही कर रहे हैं। सुओ मोटो you are competent to discharge him even when the police ask for remand under section 167. This is the question. शुरू करें जी। ये है सेक्शन 63। No person who has been arrested by a police officer shall be discharged except on his own bond or on bail or under the special order of a magistrate. ये बुलाना यार वो जो इसको फिक्स कर गया जी बेल। ये कैसे चलेगा आगे? अच्छा अच्छा, इससे ये फॉरवर्ड ठीक है, ये फॉरवर्ड ठीक हो, ठीक है। ये अब केस रहा है AIR 1957 कलकत्ता 379। Section 63 merely empowers a magistrate in a special case to make an order discharging the accused at a time when investigation is in progress. In special circumstances, the police officer may think it right to fortify himself with an order of the magistrate, and in such a case, the magistrate may direct the person to be discharged on bond or on bail when the investigation is in progress. The effect of the magistrate's order is merely that the accused has been discharged, but that cannot have the effect of interfering with the investigation. If such investigation is still in progress, the investigation will come to its natural end only under Section 173 of the Code of Criminal Procedure, either by a final report or by a charge sheet. यहाँ मैं आपसे पूछता हूँ कि ये फाइनल रिपोर्ट किसको कहते हैं और चार्ज शीट किसको कहते हैं? फाइनल रिपोर्ट किसको कहते हैं? चालान। और चार्ज शीट किसको कहते हैं? ये माइक सामने रख लें जरा। क्या फाइनल रिपोर्ट और चार्ज शीट एक ही चीज है? फाइनल रिपोर्ट क्या है?
सर चालान और फाइनल रिपोर्ट में जस्ट वो सेम चीज़ है, लेकिन डिफरेंस ये है कि उसमें इनक्रिमिनेटिंग एविडेंस मिलती है और जो कॉलम नंबर 2 में नाम पुट नहीं करते, मीन्स वो रिफ़र करते हैं या सजेस्ट करते हैं कोर्ट को कि इसको ट्राई होना चाहिए इस अक्यूज्ड को। ऑन द अदर हैंड जो फाइनल रिपोर्ट है उसमें कॉलम नंबर 2 में उसका नाम पुट करते हैं और ये
नहीं, ऐसा नहीं है। फाइनल रिपोर्ट और चार्ज शीट दोनों का नाम CrPC में नहीं है। चार्ज शीट को पुलिस रूल्स चार्ज शीट कहते हैं, चालान भी कहते हैं, CrPC में इसको पुलिस रिपोर्ट कहते हैं। तो पुलिस रिपोर्ट, चालान और चार्ज शीट ये तो है एक ही चीज। फाइनल रिपोर्ट का कंसेप्ट हमें क्लियर नहीं है, ये पुलिस रूल्स में दिया गया है। फाइनल रिपोर्ट इज ए टेक्निकल नेम, इट डज नॉट मीन फाइनल इन्वेस्टिगेशन रिजल्ट or result of final result of investigation. No, you see, Investigation results either in the form of section 169, when the police find that there is no case, and if there is one accused and police find there is no case, then what would they ask? They would ask cancellation. तो फाइनल रिपोर्ट जो है वो असल में कैंसिलेशन है, ये आपको किसी अथॉरिटी में नहीं मिलेगा। कैंसिलेशन ऑफ केस का दूसरा टेक्निकल नाम फाइनल रिपोर्ट अकॉर्डिंग टू द पुलिस रूल्स 1936. So let this difference be noted. In 1985, the import of an order under section 1863 of CrPC is none other than the release by the accused from custody. It cannot in any way be interpreted to the cancellation of a case or stopping of investigation. It is well established that the proceeding for the police investigation are over which the police alone has control, and a magistrate has no power to interfere with such proceedings. Therefore, clearly the order of discharge under section 63 cannot be interpreted to be an order of closing investigation. 1997, while discussing the scope of the provisions of section 63 of the case, it was held that a discharge under section so-and-so was relatable only to the matter of custody of an accused person during investigation. 2000, it is settled law that an order of, ये सब authorities इसी point पर हैं, आप लिखते जाएं, जो मफहूम है वो वही है कि it is the order of the magistrate when the investigation is in progress. 2000 PCRLJ 59, an order of discharge does not amount to cancellation of criminal case, means that physical custody of an accused person is not required for the purpose of investigation for the present. Pre-early 2001 Lahore, an order of discharge only means that physical custody of such an accused is not required for the purpose of investigation at present, and at any subsequent stage during such an investigation, such an order of discharge can always be recalled by the magistrate whenever it appears to his satisfaction that physically custody of the accused is subsequently required. As we just discussed, if the police needs to arrest him, then your permission is essential. In this judicial precedent, the concept and scope of discharge has been highlighted by interpreting. So I have here in this PowerPoint differentiated the scope and concept, first of all with regard to the case law, and then with regard to the statute as was interpreted in Ashik Hussein's case. Clearly those are Lahore 169, 63, 179, 170 and 173. Interpretation of section 63. This provision clearly demonstrates that the concept of the discharge of an accused person is restricted only to the question of his release from custody and nothing more. Interpretation of section 169. वो already हमने discuss किया है कि police can release him after taking his bond, and that also amount to his discharge. Interpretation of section 171. You know that when the police report under section 173 is submitted and there is a bailable case, you can obtain bail from him even in a bailable case, and that has been interpreted to be equivalent to the discharge. Such taking of security from the accused person and his release is thus possible even in a case where there is sufficient evidence available against him on the basis of investigation. This again shows that release of an accused person during the investigation on the basis of bond or security is only confined to the matter of the custody during such investigation, and the same has no bearing on the question. Same has no bearing on the question, ये note करने वाली बात है कि whether he would or would not be ultimately tried for the offense involved. Prosecution की कोई surety नहीं है कि नहीं होगी. Section 173, the word discharge appearing in section 63 and 173 subsection 3 of the code has been used in the context of releasing the accused from the custody. How, by whom, and at what stage? ये भी PRD 2001 लाहौर में under section 63 an accused person can be discharged. अब ये point note कर लें, by a police officer upon execution of personal bond by such an accused person, or he can be discharged on bail or under the special order of a magistrate if such an accused person undertakes to appear before the said police officer, a magistrate or a trial court if and when required to do so. इसका मतलब ये हुआ, इस अथॉरिटी के पेश नज़र अगर पुलिस वाला बॉन्ड लेता है उसको रिलीज करने के लिए, बेल ग्रांटिंग कोर्ट भी उससे बॉन्ड लेती है और श्योरिटी लेती है, तो जब आप उसको डिस्चार्ज करेंगे तो यू आर आल्सो रिक्वायर्ड टू गेट ए बॉन्ड एग्जीक्यूटेड फ्रॉम हिम. अगर ये प्रैक्टिस ये नहीं है, लेकिन ये अथॉरिटी हमें कह रही है कि इन ऑल द 3 स्टेजेस ही हैज टू एग्जीक्यूट ए बॉन्ड. It is further evident from the relevant provisions of the code so and so that the power of discharge an accused person on the basis of bond during the rest with the police officer, the court granting bail, or magistrate under section 63. An accused person may also be released on the basis of a bond by the officer in charge of the police station or the investigation officer under section 169, or upon taking of security in the case of bailable offence. ये वही चीज़ें हैं, यानी IO भी कर सकता है, SHO भी कर सकता है. Whether discharge is possible at the stage of remand under section 167. हाई कोर्ट रूल्स एंड ऑर्डर्स जिसका मैंने अभी हवाला दिया था, ये काइंडली नोट कर लें. पैरा 6 चैप्टर 11B वॉल्यूम 3. When an accused is brought before a magistrate in accordance with section 167, subsection 1 of the Code of Criminal Procedure 1898, the magistrate must adopt one of the following courses. Must adopt. क्या? A. If he has jurisdiction to try the case or send it for trial, meaning thereby if he is a local magistrate, क्या करे? Either discharge the accused at once. ये है सुओ मोटो इख्तियारात जैसे आपने जिक्र किया है इस हाई कोर्ट रूल्स एंड ऑर्डर्स में. On the ground that there is no cause shown for further detention, the police is asking for remand. You may discharge him, remand into police custody if empowered to do so, or to magisterial custody as he may think fit. अच्छा ये देखें, अगर एक प्रोपोजिशन आती है आपके पास, एक अक्यूज को आपने फिजिकल रिमांड में 4 दिन के लिए भेज दिया, उसके बाद जुडिशियल में भेज दिया, 5 दिन वो जुडिशियल में रहा, 9 दिन हो गए. पुलिस अब कहती है कि जिसका फिजिकल रिमांड दें, क्या आप दे सकते हैं? दे सकते हैं. जो 15 दिन की लिमिट है उस वक्त तक आप किसी कस्टडी में भेज, आइदर कस्टडी है. अब आप अगर सेक्शन 167 के पढ़ते हैं तो वहां भी आइदर कस्टडी है. ये नहीं है कि अगर एक दफ़ा आपने फिजिकल कस्टडी दे दी उसके बाद जुडिशियल में दिया है तो फिर अगर टाइम बकाया है तो आप अगेन उसको फिजिकल कस्टडी में भेज सकते हैं. और यही इस हाई कोर्ट रूल्स में कहा गया है. ये है जो रिमांड हिम टू पुलिस कस्टडी if empowered to do so. If empowered to do so, magistrate second class can't do it, and you are a magistrate first class, so every one of you is competent. Or to be magisterial custody, ये judicial remand है, as he may think fit for a term not exceeding 15 days, which term if less than 50 days, ये note करने वाली बात है, may subsequently be extended up to the limit of 15 days at all, and shall forward a copy of so and so. आगे proceed to the accused. अब है second para. अगर आप इलाका मैजिस्ट्रेट नहीं हैं और आप समझते हैं कि फर्दर डिटेंशन अननेसेसरी है, फिर डिस्चार्ज तो आप कर नहीं सकते। If he has not jurisdiction to try the accused or send him for trial, he must either, if he thinks there is no ground for further detention, at once send the accused to a magistrate having jurisdiction with a view to his trial or discharge. Meantime, अगर वो इलाका मैजिस्ट्रेट अवेलेबल नहीं है, you may send him to judicial lockup with the direction कि इसको पेश किया जाए to the इलाका मैजिस्ट्रेट who would be coming to office next day, or in the event of a duty magistrate, as I told you, your magistrate, your session judge may authorize you to also exercise the powers of an Ilaka magistrate for the purpose of remand. Subsection 2 of section 167, ये तो हाई कोर्ट रूल्स का वाला मैंने दिया। अब सेक्शन जो स्टैट्यूट है वो भी यही कहता है। Above para 62A of the High Court Rules and Orders is quite in line with the subsection 2 of section 167 CRP, which provide that if the magistrate to whom an accused person is forwarded for authorizing the custody of the accused has no jurisdiction, ये subsection 2 है, to try the case or send it for trial and considers further detention unnecessary, he may order the accused to be forwarded to a magistrate having such jurisdiction. This subsection obviously visualizes the possibility. तो ये दोनों यही बात करते हैं कि डिस्चार्ज सुओ मोटो भी हो सकता है, पुलिस की रिक्वेस्ट पर भी हो सकता है, लेकिन करेगा कौन? इलाका मैजिस्ट्रेट। डिस्चार्ज ऑर्डर बाय ड्यूटी मैजिस्ट्रेट, ये दो केस लॉ हैं, ये लिखना चाहें तो लिख लें। 2005 PCR LJ 1403, police produced the accused before duty magistrate on Sunday for physical remand, who refused to grant the same and instead discharged the accused. The order was impugned before the High Court. It was observed, line containing subsection 2 of section 167, starting from if he has no jurisdiction to try the case or send for trial and consider further detention unnecessary, he may order the accused to be forwarded to the magistrate having jurisdiction. Clearly shows that if the magistrate has no jurisdiction to try an accused produced before him for remand, he may authorize detention. Remand तो आप दे सकते हैं, but if he considers further detention unnecessary, he may order the accused to be forwarded to a magistrate having such jurisdiction. In the instant case, the impugned order was passed by a duty magistrate on Sunday. He did not have jurisdiction to try the respondent number 2. Thereof, he thought further detention unnecessary. He could have forwarded respondent number 2, the magistrate having jurisdiction. Therefore, in my opinion, the wired ab initio set aside. दूसरी है PLJ 2009, Lahore 354. In this case, the duty magistrate, section 30, Ferozwala, discharged the accused. The order was assailed by way of writ petition on the ground that the duty magistrate was not competent to discharge the accused and that impugned order was violative of section 167. It was held in the instant case the impugned order has been passed by duty magistrate. It is clear from, ये भी उसी लाइन पर है, हवाला यहाँ भी subsection 2 of section 167 का दिया गया है। Other case law on the point है कि किस स्टेज पर कब हो सकता है। As far as I can see, section 63 merely empower the magistrate in special case to make an order discharge during the investigation. फिर 1995 ये लिख लें आप, मैं इसको पढ़ूंगा नहीं, ये वही बात है जो ऑलरेडी हम 1985 PCR LJ 244, PLD 1986 Lahore 256, ये भी वही है कि आप, ये पॉइंट वो है कि क्या रिमांड की स्टेज पर आप डिस्चार्ज कर सकते हैं। हाई कोर्ट रूल्स इलाहाबाद में ये केस लॉ आपको बता रहा हूँ जो भी यही कहते हैं कि आप कर सकते हैं। फिर है PLD 1987 लाहौर 236, ये भी इसी पॉइंट पर है कि एट द स्टेज ऑफ रिमांड आप उसको डिस्चार्ज कर सकते हैं। 1997, MLD 1135, this too is on the same point. PLD 2000 Lahore 136. अब यहाँ थोड़ा सा डिटेल में है, ये मैं पढ़ देता हूँ. If for purpose of investigation, he, police officer, needs further detention of the person concerned, he has to obtain remand under section 1. The magistrate concerned has three options. क्या? Grant the remand, can refuse further physical remand and send him for judicial remand. Or the third option would be that in case the evidence against the person concerned is deficient, he can discharge the said accused. ये तीनों options आपके पास हैं. A similar view has been taken in this judicial precedent, Sheikh Hussain versus so and so. अब है कंट्रा. ये वो अथॉरिटीज़ हैं जो इससे हटकर हैं कि आप नहीं कर सकते रिमांड की स्टेज पर. (1991) MLD Section 163 empowers the magistrate either to grant physical remand or to refuse the same. The order of discharge could not be passed under the provisions of Section 167. हमने अभी इतना केस लॉ भी पढ़ा और हाई कोर्ट रूल्स ऑर्डर भी पढ़े कि एट द स्टेज ऑफ रिमांड आप डिस्चार्ज कर सकते हैं. ये अथॉरिटी उससे हटकर है. तो वो जो टर्म मैंने इस्तेमाल की थी, दिस केस लॉ इज पर इनक्यूरियम, वो यू कैन कॉन्फिडेंटली से इट. 2001 PCR LJ 498. In this case, the question as to whether a magistrate before whom accused persons are produced to obtain physical remand on disagreeing to grant the same can discharge the accused from the case was answered in the negative, particularly when the case is triable by a court of session. ये दोनों बातें गलत है. कोर्ट ऑफ सेशन में भी अगर केस है, इन्वॉल्व है अक्यूज, तो आप ही डिस्चार्ज करेंगे, सेशन जज नहीं करेगा. और रिमांड की स्टेज पर भी कर सकते हैं. 2005 provisions of section 167 do not contemplate a discharge. It is permissible only under section 169. अब देखें ना, 169 में तो पुलिस खुद आपसे यानी डिस्चार्ज मांगती है, लेकिन वो हम डिस्कस कर रहे हैं कि आप सुओ मोटो भी कर सकते हैं. Comments, it is submitted that the above mentioned three judgments are per incurium beginning against the settled law, especially as contained in the High Court rules and orders referred to above. I am not saying anything of my own. It is all supported by the case law. Competence of a magistrate regarding discharge in case exclusively triable by Sessions Court. It is settled law that a magistrate empowered to take cognizance of offence and to try the accused or send him for trial is competent to pass an order of discharge even in a case exclusively triable by court of session. आप केस लॉ लिखते जाएं. PLD 1980 लाहौर 28. ये जब लॉ रिफॉर्म्स ऑर्डिनेंस में 1972 में, जैसे मैंने कहा कि जब कमिटमेंट प्रोसीडिंग्स को ख़त्म किया गया, तो CrPC के बहुत सारे प्रोविजन जो थे उनमें अमेंडमेंट्स की गई. तो उस अमेंडमेंट्स के बाद ये क्वेश्चन पैदा हो गया कि अब क्या मैजिस्ट्रेट के पास पावर्स कैंसिलेशन ऑफ केस या डिस्चार्ज की हैं. तो मैंने जैसे कहा कि कैंसिलेशन ऑफ केस के प्रिंसिपल और डिस्चार्ज के प्रिंसिपल एक ही हैं. जिस अथॉरिटी में कहा जाए कैंसिल हो सकता है, तो उसका मतलब डिस्चार्ज भी आप कर सकते हैं. तो इसमें है कि रिसेंट अमेंडमेंट्स इंट्रोड्यूस्ड इन द कोड ऑफ क्रिमिनल प्रोसीजर बाय द लॉ रिफॉर्म्स ऑर्डिनेंस 1972 है. ये 73 गलत टाइप हो गया है, ये आपने 72 लिखना है. अगर हैव नॉट इफेक्टेड द पावर्स ऑफ द मैजिस्ट्रेट टू कैंसल मैंने लिखा है, लेकिन इसमें डिस्चार्ज भी शामिल है, क्योंकि अगली अथॉरिटी हम पढ़ेंगे तो स्पेसिफिकली आगे. PLD 1981 SCMR 267, ये मैर खां वर्सेस यकूब का बड़ा मशहूर केस है. इस केस में असल में ये मामला पैदा हो गया कि कमिटमेंट प्रोसीडिंग्स के दौरान तो आप सेशन को केस जो है उसको डील करते थे और फिर कमिटमेंट प्रोसीडिंग करते थे. क्वेश्चन ये पैदा हो गया कि जब कमिटमेंट प्रोसीडिंग्स ख़त्म हो गई और चलान आपके पास आता है और चलान इनकम्प्लीट है, आप उसमें उसको मुकम्मल करवा रहे हैं और इस दौरान आप उस अक्यूज़ को 344 के तहत क्या मैजिस्ट्रेट जुडिशल रिमांड में भेज सकता है? ये उस वक्त क्वेश्चन पैदा हो गया। या चूँकि मैजिस्ट्रेट ने तो अब एक पोस्ट ऑफिस के तौर पर काम करना है, केस मुकम्मल करवा के सेशन कोर्ट में भेज देना है, ट्रायल तो उसने करना नहीं, ना इंक्वायरी करनी है। तो ये क्वेश्चन पैदा हो गया कि जुडिशल रिमांड में अगर भेजने की ज़रूरत पड़ जाए तो क्या मैजिस्ट्रेट भेज सकेगा या उसको सेशन कोर्ट में भेजना पड़ेगा? तो ये अथॉरिटी उस पॉइंट पर है। यहाँ कहा गया कि नहीं, क्योंकि 344 जो है उसको अगर पढ़ें तो वहाँ ट्रायल या इंक्वायरी दोनों की बात है। सेक्शन 344 अगर नहीं पढ़ा तो आप पढ़ें तो दोनों बातें हैं, ट्रायल भी और इंक्वायरी भी। ट्रायल और इंक्वायरी में कोर्ट जो है वो उसको जुडिशल रिमांड में भेज सकती है।